Good day, Criminologies student. I'm JellyAnn Mercado, and today I will discuss the basic knowledge and overview of our subject, which is the Specialized Crime Investigation 1 with Legal Medicine, under the area of crime detection and investigation. The Specialized Crime Investigation 1 with Legal Medicine is a new curriculum in BS Criminology under the CHED Memorandum Order Number 5, Series of 2018. And this course covers the special study of modern techniques in the investigation of crime involving crimes against person, property, chastity, and other related offenses. Likewise, it focuses with the application of medical science in crime investigations with emphasis on human anatomy and physiology, and also the medical legal aspect of physical injuries, death crimes, abortion, infanticide, paternity, and filiations, and also to include the impotency, sterility, and poisoning. So in this subject, the student will be able to determine the approach in the conduct of investigation, particularly in specific crimes. And they are also able to differentiate crimes which are of similar nature and identify the physical evidence as a means of proving the commission of such crime in court. And also be aware of our student in the importance of proper preservations of physical evidence on a special or specific crimes, and also the chain of the custody. So before we go further with our discussion, we should address the basic foundation of our subject, which is criminal investigation. So what is criminal investigation? So criminal investigation, it by defined by PNP Investigation Manual, it is the collection of facts in order to accomplish the threefold aims, which is the first one is to identify the guilty party, to locate the guilty party, and to provide evidence of his guilt, which we are referring to the suspect. And if these three objectives of criminal investigations are successfully attained, then the crime can be said to be solved. And according to the information theory provided by Wilmer, it says that criminal investigation process resembled a battle between the police and the perpetrator over crime-related information. And in committing the crime, the offender emits signals or leaves behind information of various sorts, like fingerprints, eyewitness description, murder weapon, and etc., which the police attempt to collect through investigative activities. So if the perpetrator is able to minimize the amount of information available for the police to collect, or if the police unable to recognize the information left behind, then the perpetrator will not be apprehended, and therefore the perpetrator will win the battle. On the other hand, if the police are able to collect a significant numbers of signals from the perpetrator, then the perpetrator will be identified and apprehended. Then the police will win. This perspective clearly underscored the importance of information in a criminal investigation. And also there is a question if a criminal investigation is an art only. So actually is no, because criminal investigation, it has a semblance of science with some strict rules that must be considered in conducting it. And some of these rules are the provision of 1987 constitutions, which states that an arrested person under investigation of an offense is afforded with some constitutional rights, which to include the following. One is the right to remain silent. The second one is the right to counsel, that if cannot afford one, he shall provided with an independent and competent counsel. And the third is the right to be informed of the nature and the cause of the accusation. And take note that criminal investigation can be understood in three manners: as a process, as an art, and as a science. So, criminal investigation as a science. It is science because there is a systematic method of inquiry that preliminary applies scientific knowledge, principle, and even methodologies in order to discover and also to identify, collect, process facts and evidence to promote justice. So what is special crime investigation? So special crime investigation, this refers to the investigation of cases that are unique and often required the application of legal medicine and requires special training to fully understand their broad significance. The emphasis is on physical evidence rather than extrajudicial confessions. In investigating crimes, there are crimes categorized as special because of the complexity of nature of the offense that requires the application of legal medicine and requires an additional qualifications and highly specialized training for, for us to solve them. So, the special crime investigation is also concentrate more on physical evidence. It's collecting, it's handling, identification, and also preservations in accordance with coordinations with the crime laboratory. So, the special crime investigation is involved also a close relationship between the prover in the fields and the crime laboratory technician. They work together as a team, reacting to and extending one another theories and findings. Work working patiently and thoroughly to solve a crime from their investigative discoveries. And take note that the present criminal justice system in our countries, especially the court relies more on physical evidence rather than extrajudicial confessions. So, in order for us to understand more our discussions, there are some technical terms that we need to define. The first term is law. Law is a rule of conduct, just, obligatory, laid by legitimate power for common observance and benefits. So law has a three characteristic. The first one is it must be rule of conduct. So meanings law must be regulates or it must be regulates our actions and behaviors. So the second characteristic is it is dictated by legitimate power, meaning it must be laid by legitimate power of the lawmaking bodies. And the third one is it must be compulsory and obligatory. And there are also two forms of law. The first one is written or statutory law, or a Latin expression lex scripta. Lex scripta, or written or statutory law, it is composed of laws which are produced by the country legislations, which are defined, codified, and incorporated by the lawmaking body. Meaning, written and statutory law are produced, defined, and codified by the lawmaking body, which here in the Philippines, our lawmaking body is the legislative branch. And some sample or of written or statutory law is the Philippine laws. And some sources of our Philippine laws is uh, the constitutions, the 1987 Constitution, which is we define as the mother of all laws. Then also it includes the statutes, which cover the or it including the acts of Congress, municipal charters, and courts of rules, and so forth. And in Philippine laws, it also the sources, or there is some sources like the treaties, conventions, and the judicial decisions. So the second point of law is the unwritten or common law, or a Latin expression lex non scripta, which is contrary to the first forms of law. So it is, when we say unwritten or common law, we are referred to a case law or common law or jurisprudence or customary law that based on immemorial customs and usage. And an example of unwritten law is the law of England. And take note that common law is not applicable in our country. So the next batch of terms, technical terms, is forensic. Forensic, it denotes anything belonging to the court of law or used in court or legal proceedings, or something fitted for legal or public argumentations. So when we say forensic is that all relating to the application of scientific tests or methods and techniques to the investigation or detection of crimes, we call them forensic. So what is medicine? Medicine is a science and art dealing with prevention, cure, alleviation of disease. So medicine, it can also applied as a science and as an art of diagnosing, treating, curing, and preventing disease, and also relieving of pains and improving the health of a person. So our next term is legal. When we say legal is, it pertains to law arising out of or by virtue or of or included in law. So meaning, when we say legal, it is that anything that is permitted by law, we considered it as legal, or you are allowed to do it, or you have to do it by law, we call it legal. So our next term is jurisprudence. Jurisprudence is a science of giving a wise interpretations of law. So meaning, from the word jurisprudence, jurisprudence is also a Latin terms. From the word jus or jur, it is a Latin word which meaning a law. When we say prudence or prudentia in Latin word, we are referring to a knowledge, meaning jurisprudence is having a knowledge with law. So, having with knowledge of law or wise interpretation of law for the purpose of applications to all cases. So what is legal medicine? Legal medicine, this refers to the branch of medicine which deals with the application of medical knowledge to the purpose of law in the administration of justice. It is also part of medical science which is deployed by the legal authorities for the solution of legal problems. So meaning, legal medicine is the applications of medical knowledge to the law. So when we say we are applying medical knowledge to the law, it is for the purpose of making clear or easy to understand the legal problems. That is legal medicine. And in definition of our legal medicine, it is defined by Dr. Pedro Soles and de Lagonera. So, who is a medical jurist? Medical jurist is a physician who specializes or is involved primarily with medical legal duties is known as medical jurist. So, medical jurists, as long as much administrations of justice is primarily a functions of the state physicians, whose duties are mainly medico-legal in natures, are mostly in the service of the government. And medical jurists can be used interchangeably with medical examiner, medical legal officer, and medical legal expert. So what is medical jurisprudence? So medical jurisprudence, it is the knowledge of law in the relation to the practice of medicine. Meaning, we are applying law in the practice of the professions or the practice of medicine by the medical practitioner. So meaning, we are applying law, knowledge of law, especially when it concerned with the rights, duties, and obligation of medical practitioner. And most of the time, we are referring to the relationship of doctor and patient. So our next topic is the principle of stare decisis. So stare or doctrine of stare decisis, from a Latin term that to stand by things decided. A principle that when the court has once laid down a principle of law or interpretation as applied to a certain state of facts, it will be adhered to or applied to all future cases. Meaning, stare decisis is a legal doctrine that obligates courts to follow historical cases when making a ruling on a similar cases to ensure that cases with similar scenario and facts are approached in the same way. So I think I will end up our discussion here and wait for the part 2 of our discussions with CDI2, Specialized Crime Investigation 1 with legal medicine. I hope you learned And thank you, and God bless.